Добрый день.
Hello, good afternoon, dear participants. So why don't you take your seats and we shall start the session about intellectual property. So while everybody is taking their seats, I will start. First of all, I'd like to draw your attention to the fact that our session is called Intellectual Property Protection. And there's some intrigue in the title of this session, because today we are going to talk about the protection of intellectual property. So it's better to be translated as enforcement in English. And I'm going to focus on the fact that if there are no items of intellectual property that are to be protected, then there's nothing to protect. First of all, let me introduce the reporters that we have today, our panelists. They are Ivan Bliznetz, the rector of the State Academy of Intellectual Property and the Federal Service of Intellectual Property. We also have Anna Kostyra, who is a partner at Ernst & Young Company. And we are also having Alexey Kravtsov, and he is the presiding judge of the third-party arbitration court of Moscow. So it means that we'll be able to analyze the issue related to intellectual property from different perspectives. And today, among our reporters, we have those people that work in education and civil and state service and public service and private business, and also those that represent courts. So I guess we'll have an opportunity to identify those problems, those difficulties that somebody might face, and maybe provide some practical recommendation as to what you should do, as well as see what can be done to enforce intellectual property protection. So I'd love to say a few introductory words and outline what we're going to talk about. Whenever we speak about intellectual property, we're going to consider patent law. And patent law is related to patents for industrial models and topology of integral schemes and many other things. We're going to speak about copyright and related rights. So whenever we speak about intellectual property, it's a means of individualization. The Russian legislation, as well as legislation in other industrially developed countries, it covers trademarks, origin of production, company names. And one other thing is when we speak about Russian legislation, intellectual property includes know-how or the secret of production. At the moment, we have quite well-developed system of intellectual property protection. Today, there are different opportunities to defend the rights in an administrative way. If you, for example, do not agree with the decision of the Federal Service of Intellectual Property, if they registered some item or, for example, made some unlawful decision, and then you can appeal this decision in a legal proceeding. You can also go to Federal Customs Service that introduces or enters the items of intellectual property in a special register. to make sure those items of intellectual property are not smuggled. We also have anti-monopoly service that makes decision related to unfair competition. And one of the articles related to the law on the competition, if the Federal Anti-Monopoly Service concluded that some intellectual property was used for unfair competition, you can go to competent authorities to terminate the registration of such item. So there's also an opportunity to go to the third-party law and court. So there are some effective tools that are available. But what worries me most whenever I think about intellectual property protection through the eyes of entrepreneur, I can say that every item of intellectual property has certain mechanism for property protection. If we speak about copyright, there is a very strict mechanism for protecting the right, but we don't have similar mechanisms with patented items protection. You can go to customs service and enter your trademark in the register of the items protected by intellectual property rights. So whenever we speak about patent law, these instruments don't work. And I'd love to ask my questions to Ivan Bliznetz. So how effective are the mechanisms for copyright protection? And maybe we have some effective measures for some items and not so effective instruments for the items protected by patent law. Good afternoon. So the topic that we are discussing today has been the subject for discussion of many different forums that took place here in Russia. But the main focus in such discussions is made on copyright protection, copyright and related rights. You probably remember the time when Russia was trying to enter WTO, and one of the most problematic areas during the negotiations were related to protecting copyright holders. And this was related to the fact that this is a business which is most demanded and most well developed. And the USA lobbied this issue, trying to protect their investments and protect their business. And there are well-known figures that the specialists turn to when they say the GDP of the U.S., intellectual property rights bring a very high percent, and that's why the Congress of the U.S. is interested in these issues, because they want to protect the interests of their business. And if you heard about this, you know the report 301 prepared by the Congress And it basically describes the process of intellectual property protection in different countries. So today, I wanted to focus on this. Since you are all entrepreneurs, I can see many young faces, young girls and boys, but I guess you're related to business. And you understand that industrial property also needs protection. Whenever we think about some useful models, inventions, trademarks, industrial models. So while discussing all these things, we have to find possible practical opportunities that help us take effective measures to protect all items of intellectual property. Another thing that I wanted to focus on is that usually people speak about different laws. For example, why don't we introduce another law? Why don't we introduce this or that to the civil code? But I can assure you that I can tell you about my personal practice. I've been dealing with intellectual property rights for 20 years. I've written lots of papers on that. So today, there have been created very effective norms and regulations and legislation here in Russia that helps resolve different issues related to intellectual property right. In terms of some legal compliance procedures, maybe we are a bit behind. And a significant step is a setup of a court for intellectual property. This is a very important step that helps us improve our legal law enforcement practices in the intellectual property area. And of course, the right holders should be interested in this, first of all. You should understand that the protection of any item of intellectual property is private business, and the state not always cannot sometimes solve the questions related to protecting some objects. The state has to provide an appropriate legislation that helps solve those issues. But then, speaking about law enforcement and actual legal practices, this is the competence of the right holders, because they have to defend their rights themselves. Before this meeting, we had some discussions. And we wanted to make this talk not around our lectures, our own opinions. We wanted to make it a real discussion, an interactive discussion, so that we could raise those issues that worry you and identify the most problematic areas related to intellectual property protection, and maybe identify the solutions and some practical steps that can help improve the situation and can help the business manage the intellectual property effectively and protect it, because this is, again, a key issue which is crucial for us. Otherwise, we won't be able to progress. If we want to create an effective economy, we speak about innovations, and innovations imply intellectual property protection. So we have to ensure we have all the laws and rules that help protect different copyrights and intellectual property. We analyzed the situation in the United States 2 weeks ago. We came from the South Korea. We met some business representatives and government representatives. So it was very interesting to know their experience related to law enforcement in the area of intellectual property protection. So the developers and right holders receive rewards or benefits or revenues from the appropriate legal practices. They send claims to violators and get some benefits from the items of intellectual property. So this is briefly what I wanted to say, and I'm ready to discuss the issues. Thank you very much. We cannot but agree with what Alexandra said, and I remember a talk that I had with American patent workers that I had 20 years ago. And when I asked why American companies never patent their inventions in the Russian Federation, they asked me, can you give me some statistics? How many disputes have you considered related to intellectual property rights, and what solutions or decisions the court make? And we didn't have such disputes. So if we cannot see how we can protect the rights, we'll never make any efforts related to getting the rights for intellectual property. Of course, it's possible, but only as part of the large company strategy. But if we speak about small companies, it's very difficult.
Today, the situation has changed significantly. In 1995, there was no statistics. In 1997, there were about 300 cases connected with disputes on intellectual property rights. Figures for 2010, 11, and 12 are as follows. In 2010, arbitration courts reviewed 3,234 cases. In 2011, 2,096, and in 12, over 5,000. Speaking of illegal use of trademark, it is about 4,929, and respectively in 2012, 4,314. So every year by 14 or 20%, the number of cases is growing that is reviewed by the arbitration court, as well as by civil courts. Actually, court on intellectual property rights within the system of arbitration court is quite active now. And we need to ascertain that the time framework for reviewing cases is quite long, and costs are significant. Sometimes, and as a vice president of OPORA Russia, an organization that supports small and medium-sized business, must say that small and medium-sized companies cannot take the burden of these legal expenses. Sometimes they have to capitulate or look for opportunities to cancel this dispute, even if they have to take losses. So the next question is to Alexey Kravtsov. Alexey, probably today in Russia we can't say that Arbitration courts are very popular. Maybe I'm wrong. Could you clear up these matters? How useful or effective are they, and how could we use this mechanism? Maxim, you haven't received these documents. Okay, then let's listen. One of the specific features of arbitration, which makes it different from government courts, is that sessions are closed, court sessions, and arbitration courts cannot publish their awards the way the government courts do it. They are open. So information about how and what the court practice is, you can only hear it from public statements only and get only general information. I'm a president of the Union of Courts of Arbitration of Russia, and I must say that business is shifting to this system. They are leaving government courts and are shifting to commercial arbitration. For example, a man invented a concrete plate which is placed between tram rails, and he patented it as a useful model. So concrete factory approached him, and they said that they had an order for tram rails, and they suggested that he gives them the documents, and they will sign an agreement. They made 1,000 slabs, and in 6 months, this man finds out that based on his technologies, the factory continues manufacturing the slabs. And he found an object where these slabs were already used, 200 items. If he files a suit against this factory in a government court, what do you think how much time he will have to spend on this suit? About a year. Each judgment can be appealed against every time. If you take a usual individual, the defendant will be a big factory with a whole staff of lawyers. So any lawyer, more or less educated, knows how to use procedural tools. He will know how to do it, how to make the process very long. In a year, money will be different, will lose their value. I mean the compensation on this contract. I participated in this case. So when he signed the license agreement, he signed into the procedure for the resolution. He included arbitration courts. This means arbitration reservation. It is an item, a provision. So in case of a dispute based on the plaintiff's choice, it can be reviewed either by a government court or by an arbitration court. By signing this agreement, the parties envisage the second method, not just government courts, to review disputes. I don't have much time to speak, but what are the advantages of the arbitration court? Arbitration court reviews cases in one court session, and based on the law, the awards of the arbitration court cannot be appealed against. In my court, sessions start on the 10th working day after the lawsuit is filed. If you file a lawsuit today, in 10 days you will have this session. Why is it so fast? And why does in the government court the periods between sessions is between 1 month or 6 weeks? And because documents are delivered by the post of Russia, and this post is very slow, extremely slow. Arbitration court uses express post like DHL. So tomorrow the plaintiff will get a receipt. Of course, it is 5 times more expensive as compared to the post of Russia, but much more effective. So the defendant has 9 days to prepare for the process. And the award of the arbitration judge becomes effective immediately. You can't make this process lengthy. And the awards of the arbitration court are to be fulfilled either on a voluntary basis or based on the court order. It is a technical procedure, and it takes about 30 to 40 days. So at the first stage, the award is obtained on the 10th day, and you can comply with it on a voluntary basis, or in 30 or 40 days, the court order is received, and bailiffs do the same work. However, in contrast to the court orders that you bring a year later, of course, it is clear that this company has already disappeared. And if you bring this court order in 6 weeks, it is fresh, hot, as collectors say, and you have something to work with. So the time framework. Second, legal entities and natural persons, irrespective of their jurisdiction. And the third advantage is this: the arbitration court reviews cases no matter where the parties are located, in any part of Russia or in Western Europe. Any arbitration court will review your case at the place of its location. For example, if you are in Moscow and your defendant is in Vladivostok, you can write the Arbitration Court of London, and you will go to London for your case to be reviewed. If you sign an agreement with a company in Berlin and you include Vienna Arbitration Court, your case will be reviewed in Vienna. If you are in Russia and you sign an agreement with Saratov and you indicate the Arbitration Court of Moscow, your case will be reviewed in Moscow, no matter where your defendants are. In the government court, your case will be reviewed at the defendant's location. So if you are in Moscow, you will have to pay the lawyer for his work. You will also have his travel expenses, etc. It makes the process much more expensive, and many people refuse to do it because they don't want to deal with the system. These problems were solved long ago in Europe. All commercial lawsuits are reviewed by commercial arbitration courts. Government courts do not review economic issues. In Western films, you can see, I will file a lawsuit, and so this person will react accordingly, will be intimidated, because all the commercial contracts in Europe include commercial arbitration, and counterparties understand that they will be dealt with shortly. In this country, if you say, I will file a lawsuit, your opponent will smile. Because in this country, people understand that a trial can last forever. In Europe, they understand that their case will be reviewed very soon, and this motivates him to fulfill this contract in good faith. When a company starts including arbitration reservation, in their contracts, I mean a company that builds playgrounds for children, and they have a lot of suppliers from all over Russia. And when they started using the system, they filed lawsuits twice a week, and they had a lot of issues connected with quality or time frame. A year passed, and now they file lawsuits only once in 2 or 3 months. Once I talked to the head of this corporation, I asked him about the statistics. He said the range of suppliers is the same, and when we included the arbitration reservation, we demonstrated this reservation in action. So next time they will either avoid signing a contract with us because they understand that in case of violations they will really have to go to court, and or they try to fulfill this contract on a timely basis, or even before it expires, because they understand that they will have to bear all the expenses. The motivation of the counterparty grows significantly. And in Europe, business is civilized because things are moving fast. We are only moving in that direction. I have a question. By this example, I showed the main aspects, and if you have any questions, they always arise after my presentations. Well, you can ask them, and this will be our discussion. Just a couple of things. You have described the positive aspects, and it's clear why. And I would like to draw your attention to the fact that statistics show that over half of cases in the sphere of intellectual property is connected with challenging the decisions of the Federal Intellectual Property Service. It's obvious that arbitration courts only reviewed a certain category of disputes. To what how big is this category? I will also discuss information. In fact, these issues that are in your jurisdiction are not even shown statistically. Maybe it's the problem statistics, I don't know. This information was not included in statistics. We only publish it Our union is the only professional association that accumulates all the information from the regions and publishes it. Government institutions do not use this information. We are just two parallel systems. Arbitration courts are not part of government courts. We don't overlap. Arbitration court can be compared to a notary public. They are authorized to review cases judicially. So this information is not available. Our arbitration court can only review cases when there is a contract, an agreement containing this arbitration reservation. We don't review arbitration cases. Arbitration court cannot review public relations without any agreement, like violation of copyright, where there is a contract, a license agreement, which deals with the violation of certain rights of the right holder and the ability to compensate all the expenses. By the way, the end of that story was as follows. When the agreement was signed on these concrete slabs, the patent lawyer who conducted this agreement advised his customer to include arbitration reservation into the agreement. And they also included a provision that in case the factory makes more slabs than provided for by the contract, it will have to pay compensation, a tenfold compensation. So in case when the contractor confirmed that this concrete factory provided this slabs, they filed a lawsuit to the arbitration court, and in 10 days they got an award for recovering tenfold compensation. In 40 days, he got a court order, and the plan, the factory was an ongoing concern, and they got all the money. The lawyer, after the session, was surprised. He asked, "Is this all? Can we appeal against the case?" "No, you can't. That's it." So this person got his money, and next time the factory will be much more attentive. The arbitration court is a short way to an award. So a person will be afraid to violate his obligation because he will be held liable. These are contract relations. Everything else, well, you can discuss these matters in government court, though it might take you several years.
I have a provocative question, maybe not so provocative. If I were an entrepreneur, and I understand all the limitations related to the authority of arbitration court, but what I'm interested is this, and we know that there's a separate court for intellectual property rights, and actually it's really strange because the court is new, but the judges are old. But again, we can discuss it later. What I meant to say that this is very difficult. They're very difficult disputes. So, do you have highly qualified judges that can consider all these disputes? Because even when you were telling us this story, you know, of course, there are different ways. For example, the plant could come up with some suggestions, with some ideas, because if I put myself in the plant's shoes, I can think of some arguments I could give. Then you said that there must be this provision in the contract, but I'm sure that this suit was outside of the contract. Probably they wanted some compensation because the right was violated. Yes, it was a tenfold compensation because they did not honor the agreement. Thank you, Anna, for this question. It's a great question. So that's the difference between the state court and arbitration court. The state court, I hope I don't offend anybody here, because the judges that work in the state courts usually come out of the secretaries that used to take the minutes at the meetings. So these young girls start as secretaries, and then over the years they become the lawyer, but they have a very narrow scope, so to say. So, of course, they will get the education, will get all the papers, but arbitration judge is a different person, is a civil person. It is required for such a person to have some work experience in economic sphere. For example, if we speak about intellectual property right, they must be the leaders of organization for patent representatives, for patent lawyers. So they're not only highly qualified lawyers, but they know the system from inside and out. They know who the licensee and the licensor, and they know what they do. So the quality of dispute consideration is much higher because they know the system very well. So that's the difference between arbitration court and state court, just because they know practical practices very well. Then I wanted to ask you one other question. When you speak highly qualified and not so qualified, we are interested in transparency. When you have access to the judgments made by arbitration court, you can evaluate the consistency, whether they are in line with the law. So arbitration court does never publish their judgments and decisions. Yes, we are prohibited to do that. But from the entrepreneur's point of view, when they include such provision in their contract related to arbitration court, maybe it's something weird, like a pig in a poke. That's a very good question, too. Everybody knows that in a national court, the subordinate instance usually considers the higher level and their practices. So in other districts, sometimes there are completely different decisions made by the court. So the lawyers that go to the national court see it as a lottery. For example, what decision of a federal anti-monopoly service they're going to consider, and the judge can always juggle this decision, which results in corruption. Arbitration court is not part of state court. We do not obey the decisions made by FAS and other organizations. Arbitration court considers the suit based on the contract only. So we never think about different interpretation of laws, because one person says, this is my interpretation, Supreme Court says that it's a wrong interpretation. That's why they're trying now to approximate their procedures. And the Federal Assembly speaks about the importance of developing arbitration court system in Russia. The Russian Federation has joined WTO, so foreign investors are interested in all the legal proceedings. So all these foreign investors say that we don't want to deal with your local legal system, and they started to include their foreign commercial arbitration courts in the contracts. So where are all our entrepreneurs going to go? To London, like I said, or maybe America. And therefore, the costs, the legal costs, have increased manifold. That's why it's so important to develop arbitration court. And it means that this country is willing to set up a fully fledged legal system. Because, like I said, entrepreneurs can include different provisions in their contracts, and they can choose either arbitration court or national court. One other comment that I wanted to say is related to judges. In the national court, the chair of the court or the chancellor appoints the judge. And as to arbitration court, the parties elect the judge. There is a list of judges on the website, and let's say you are a plaintiff that wants to take a legal action, and they can indicate who they want to be their judge. So let me make some comment. Otherwise, the audience will think that all our judges used to be secretaries and do not have enough expertise. I can tell you that I was working for the presidential administration, and the president himself appoints judges, and of course they focus their decisions on qualifications. So there are very few secretaries that work as judges now. But let me draw your attention back to intellectual property and how we can protect it. Of course, I agree that arbitration court has more effective instruments to consider disputes, and of course they can do it much faster. You should understand that any item of intellectual property, we had this example of industrial model. So any item of intellectual property doesn't have as long lifespan as a trademark, for example. So to change and to prepare a different industrial model is not that difficult. That means that you have to take your action as fast as possible if you have some conflict of interests to get some revenues if the model was used illegally. So arbitration court, of course, is more effective, but our society is not ready yet for this. We have our colleagues that work on intellectual property rights. And so how many applications did they get in 4 to 5 years? 0? 50? No, 0 applications, 0 claims have been sent. So we don't have such practices yet. And let's think together what we can do to find the tools and mechanisms that can help improve the situation. Of course, arbitration court is very important, especially with regard to intellectual property rights. I revere Novoselova because she is a great person, a great specialist, and she is deeply involved in this issue. So she wants this system to develop not only at the state level of dispute settlement, but also one of the key issues that is related to the court is mediation system. So we work together with the Chamber of Commerce. We have concluded an agreement, and we hope to deal with this together with the Court for Intellectual Property Rights. Maybe you have some suggestions or ideas related to the best ways of intellectual property protection. Let me make a short remark. So the majority of disputes related to intellectual property is violation of the rights, but sometimes the violator and the copyright holder do not have an agreement, so we can't really go to arbitration court. Another thing is appealing the decisions made by Rospatent, so we can't really go to arbitration court again. I agree that it's important to develop the mediation system. And the Court for Intellectual Property Rights does a lot of work. They say that it's important to continue this work, and entrepreneurs, the Chamber of Commerce, OPORA of Russia speak a lot about this. One thing is we feel there's lack of trust in Russia to these courts, and on the other hand, the level of knowledge and awareness is quite low. So we can see that the level of our judges does not match to the current requirements. Of course, some mistakes are inevitable, but then the entrepreneurs get affected by this. So that's another factor that should make us entrepreneurs unite our efforts, try to solve all the disputes through negotiations. I'd love to share my experience. We are not only supporting transactions related to intellectual property in particular. And of course, it's very important to structure your work, but we also go to the courts and defend our interests. So speaking about positive tendencies that I can see here, we managed to conclude 2 international agreements and related to international rights. So the right holder alienated their right for the trademark. Of course, when it happens, you can lose the trademark, and then other parties might get involved. So in the old time, it was very difficult to get this agreement, but we managed to conclude 2 agreements like that in the autumn because we had 2 transnational corporations involved in this process. Another thing. I'm a long-time practitioner. I've been dealing with courts for 20 years. So now the court is not sure about Ross patent decision, and they always doubt those decisions. Before that, the judges not always considered the issues related to sanctions, and sometimes the judges could not make their final conclusion, so they used expert evaluation, and they involved experts into this process. And now I can see a new trend. Now the court considers all the circumstances and situation that used to be assessed by external experts. So it means that some practices have changed, and that's a positive trend. Of course, we continue working with judges. We participate in different joint events, trying to get the message across from the business community, but we aspire for consistency. For example, when we try to get some compensation if there are some violations related to trademarks, for example, related to false goods, whether it's related to just one item or a line of products. So it's difficult to calculate the amount of the suit. So there are some basic things that are difficult to identify for the court. So it would be good if they could do this easily. And maybe it's a big plus that they don't publish their results. But for me, it's very important to analyze the current practices, and I also consider the qualification of a judge in order to understand why this or that judgment was made. So it's very important to have an idea of all kinds of practices that are available there, maybe sometimes contradictory, rather than not understand something. So I can think, I should say that the National Court has more pluses, but of course if we speak about different countries, they have a different culture and different school of arbitration courts. I'd love to remind you of this saying that even though it was very pricky, we continued eating cactus. So it means that everybody continues dealing with the same issue, despite that there were some difficulties. And just lawyers think that the only humane court that we have in Russia is the National Court.
Our task is to show different mechanisms, and we should use each of them. I think we have approached another subject shown in our agenda. Practice shows that the most of the decisions of Rospatent challenged against in court are trademarks. Out of 249 court judgments in 2011, 2011 were connected with trademarks, and others were useful models and industrial designs. 239 are on trademarks and 185 on inventions and industrial designs. A very important issue which we often see in practice. Very often errors made by Federal Intellectual Property Service are the reasons for conflicts. They provoke big disputes on intellectual rights. We, OPORA of Russia, are very concerned about the fact that Rospatent actively registers descriptions. For example, the image of a toast is patented, and the owner of this trademark starts suing all companies who use the drawing of this toast on their packages. Companies are closed. Business stops. Very often these companies are in regions and are town-forming, city-forming companies. For example, there is a medicine, Sulsen, and Rospatent registers Sulsena. And there is a conflict when the owner of Sulsena ousts everybody using Sulsen from the market. For mineral water, Sarova is registered. The name of the location is registered, and the owner of the trademark ousts everybody from the market. A lot of disputes about inventions. It's difficult to discuss technical difficulties. However, in our deep conviction is that mistakes of Rospatent provoke such scandals. However, we need to say that it's extremely important to have this intellectual property, because if you don't have it, there is nothing to protect. So, based on your rich practice and experience, could you tell us what can be done to provide the protection? I will probably give you a few examples. I'm Anna Kostyra, and 50% of my projects are connected with transactions with intangible assets. It's an accounting term, and intellectual property objects are alienated. We have a lot of disputes with business when we say if you have intangible assets, it should have signs to be protectable, because very often we see mistakes of business. What is the result of intellectual property, intellectual right object, and intangible asset? If I may, I would like to say that the root of the problem is here. Every day, performing due diligence of companies that are going to circulate their intellectual property, alienate it, or transfer these rights, sell a company as a property complex, which includes intellectual property. We often see the same problem. Business thinks that de facto it has intellectual property, and de jure big expenses are, in best case scenario, are capitalized as expense, and the accountant capitalizes these expenses, and then the accountant amortizes these expenses, and de jure we can't see intellectual property because business is convinced that design, documentation, technology, interesting solution, methodology, etc., dossier for a medicine, we have seen this too. It's a whole list of them. In terms of business, they are objects of intellectual property. However, there is no formalization. And in the accounts of company, they only have patents and trademarks for a very low price. Copyright for design documentation are not recognized or formalized. Know-how is not reintroduced on a timely basis. The company can say, I have a customer database. You look at it, and then you see in terms of civil law, it is not formalized. To be such object, there should be copyright for it. So expenses are incurred, however, there are no assets. And we assume this mission, and we start with a training seminar. We explain what is a read and how it can be commercialized and how it should be formalized, and then we propose different methods to our customers. I am not discussing trademarks now because my colleagues have already discussed it. A solution is like a peak of a volcano. What preceded this solution? A lot of studies and research. This whole part is ignored, and we come and say, your intellectual property is not formalized. And we help them to do it at an early stage, telling them where they can introduce know-how. Or suppose there could be a big IT company, and their main maxim is IBM program. However, codes are also a valuable part. Nobody is thinking about formalizing the right to codes. Codes are protected by copyright. Very often, programs are made on the basis of codes, different codes, and we teach business to make their reads negotiable, and we give them the proper format. Then pragmatic aspects start, like tax, accounting, intergroup licensing, when one company can provide access to its technologies to other companies, and they get a license fee for that. We teach our auditors to live with intangible assets and accept them. Very often business says, you have identified the object of intellectual right, and now we'll go to an independent assessor and have it assessed. Then we'll account for our assets based on the market. This should be done to be attractive for investors. In terms of accounting, you can't reassess intangible assets if you want to capitalize intangible assets and taking into account other expenses aimed at creating intangible assets. This is an endless subject for me, and I can talk forever about it. Another important aspect is transborder rights. It's the second headache. When as technology from abroad is licensed, and we understand that we have requirements of a code which says that intellectual property need to take into account rules of law of the accepting side. If we license something in Russia, we need to take many aspects into account. The agreement should comply with the imperative rules of Russian legislation. I will give you an interesting case. The main thing is to decide if the object is an intellectual property object. Well, for example, domain names. Very often licensed object include domain names, and it is not regarded as intellectual property rights. There are other ways to transfer intellectual property rights, or there can be a mixed contract. Now, know-how, we have different requirements for recognizing an object, know-how as an object. In American know-how, it is less formal for know-how to be recognized as such object. In such cases, we recommend and additionally check it for compliance with our requirements of Russian legislation. After that, we can license the know-how created in America quite legally. Business reputation, when it is within the framework of licensing or transferring business methodology or licensing business reputation, and it is not regarded as intellectual property here, and it can't be the object of law. So the technology. The most popular approach is to license technology. Technology is not regarded in Russia as intellectual property. We look at property, copyright, database, and we look at this cross-section. We decide which of them can be registered in Russia. They should comply with imperative law. You know that as of the 1st of April, we won't have to take license agreement to Rosspatent. We need to notify them only that we have signed 1st of October. It will make the life of companies easier. Beginning with the 1st of October, we won't have to check your license agreement for the requirements of Rosspatent. We see a lot of problems, which makes it more interesting. We have already solutions on trans-border transfer and what should be done when we sign a license agreement about foreign property rights. You need to choose the law which you want to govern the agreement, and then you should check the agreement for compliance with Russian imperative requirements. Then you should have you should include arbitration reservation, a lot of details on trans-border transfer, and such agreements should be prepared very carefully by companies. All the payments you receive under such agreements might be legally unjustified. So sometimes we have to prove compliance with the Russian legislation. When we had to prove that the payment of royalty is legally justified and economically feasible. This is this is all in a nutshell. During the break, I am prepared to discuss details. We, as consultants, are always ready to help you, and I'm sure that the 21st century is the century for intellectual property. I think that this is the most interesting sphere. Corporate law is not so interesting. I must apologize, but this is my opinion. Intellectual property is very extensive. And I have a question to the audience. Now questions from the audience. We'll try to answer them. Artem Tkachov, Finance Invest, Vladivostok. I would like to say that I have a practical question, and we have no representatives from state arbitration because I would like them to answer this question. However, I think that participants might answer it. Maybe Ivan. We are now discussing an important issue. We are a company whose copyright was violated in October 2013. Our website was copied by our competitors. They took everything, the contents, the design, they only changed the logo and the telephone number. We filed a lawsuit to a government court. Unfortunately, arbitration court could not be used in this case, and now we are discussing it. We don't have this practice. We are in the Far East, and I'm not only the owner, but also a practicing lawyer. And I must say that court practice in the Far East is very different from the West, and their judgments are different. So what is the practice of protecting copyright for websites, and how do courts approach such issues? Another question about the compensation regulated by civil code, where the framework is quite broad, from 10,000 to 5 million. How is this problem solved by courts? What do they focus on? What do they focus on? For example, our lawsuit was for 3 million rubles. We would like you to explain what is the practice here or in foreign countries. This is a permanent issue. Every holder of copyright has it. We can't have legality in Ivanovo, Kaluga, or elsewhere. We have a uniform legality. Part 4 of the Civil Code governs copyright and adjacent rights. There is a decision of the plenary session of the Supreme Court and Arbitration Court on Part 4 of the Civil Code. Permanent practice of general jurisdiction court is, well, they normally general jurisdiction courts review review copyright. The protection is provided in such cases always, and if necessary, you can invite experts. Our academy provides a lot of expert opinions in reviewing court cases, and we are always prepared to provide assistance in this area. As to court compensation, this practice is not yet formed, or rather it is formed but not very well. Courts, by recovering compensations, are oriented towards a kind of average system which exists in the country. The maximum amount that is recovered is under 1 million. This is the maximum amount that can be recovered. Normally, these are small amounts, irrespective of the adequacy of this or that violation. No court will give you 3 million when the maximum amount for the site is 5 million. The violation should be adequate to the compensation.
But we have some examples from St. Petersburg. For example, last year in St. Petersburg, the society, the Association for Collective Management, actually drew 5 million rubles, and the court made this decision. So I guess it's the matter of practice. Let me make a short comment. We never had any disputes related to copyright issues, but if we speak about compensation, the compensation is different from losses because you don't have to prove it. So the courts recently have charged quite large compensations, and we can see this trend. If you feel that you have incurred big losses, you have proved this. But the main question is, do you know the other party? Whether this other party will be able to pay you that compensation. Because if we speak about violating rights and copying websites, it's very difficult to find the defendant. That's the most crucial issue. It's true that we have the growing number of disputes, but the competences of judges are different. And we have a lot of disputes related to copyright and trademarks and other things. And I have to admit that some courts do not have sufficient qualification. Speaking about cassation, whether it's the cassation of first instance or not, it's going to take place in the court for intellectual property or copyright. So the competent court for the copyright should consider this case and make a judgment. Sometimes the court for intellectual property considers such issues, but there are two instances related to this court for intellectual property rights. The first instance and cassational court, so there's no appeal, and that's what we're gonna have. So, of course, it's not a question of whether it's good or bad, but if the copyright is violated, there are usually 3 instances, but we have only 2 instances. So the question is why it happens, why some enjoy privileges and why don't. Can I also answer this question? Speaking about compensation, for example, if you want to charge 3 million, but this amount is refused and you get only 1 million, you'll be a losing party, and it means that you'll have to pay not only state fee, but also the lawyer's costs. I stand against these practices, so I ask you to be very attentive, because you can make a mistake there. And it's very important to fix your copyright. We usually ask our clients to do this through the Library of Congress of the US or take other measures. And we have some know-hows when we show our clients how it can be best done in the interest of our client. So you'll have to prove who was the first, and then it's also related to the formalization of copyright related to physical person that created the site, who developed that site. First of all, thank you very much for your comments, for your talks. I'm the director of Media Group. So I faced a huge violation when I started working. We released a disc and the software to celebrate the anniversary of our city. And a year ago, I saw my disc selling in different shops. Then I saw that the label on my disc was different, and it was given as a gift to children on behalf of the president. And those people got a lot of money for that project, whereas all the essences, all the content of the disc was ours. So we were the authors of this project. So I asked Kuskov and company, and he tried to solve the problem, but there were two competing parties: presidential office and our local authorities. So, but we couldn't solve this issue. So whenever I conclude the agreement, I always mention that all our designers, software and developments belong to the designer, and this all makes our unique property. But the customer always asks us to make one provision. Whenever we transfer software, we are the owners of this software. So so what should we do next? Because, of course, we make this copyright marks, and they also do it. And I can already see that product has been reproduced. So what can we do? First of all, we can get rights only on the copyright, if it on the item that's protected by copyright. For example, when you finish your process and have created something, it's very important to say what has been created and what kind of rights you transfer. So, of course, any creative process is unpredictable, but it's very important to protect it with the copyright. This software is the only object when the copyright is held by the customer, and the rights for the software belong to the party that ordered or commissioned that product. So if you think that, I paid, so it's mine, no. The contractor have to transfer the rights. There's no concept of unified object. When when there was just one object protected by all kinds of rights, but sometimes the rights for the software belong to one, and the rights for design belongs to somebody else. But how can we distinguish between design and software? And so if you if you can't agree, then you can't do anything. So it's very important to identify how you're going to use those rights. So there is a concept of single technology, but there's no concept of the single object created by entrepreneurs. But anyway, you can come up to me later and we can think about it. I don't see any complications here. There is the concept of copyright and the industrial property. Then there is property right. So in line with Berne Convention and our civil code, whatever is created by the author is the object of copyright. So it has to be protected once it was launched, and there are no problems. Of course, it's important to register this, but if you can't prove that you did it first, then it's more difficult. But anyway, the service for if the service for intellectual property right is going to be created, then it will be much easier for us to deal with such issues. But now you don't need anything like that. Then there's service product or work-related product, and no matter what you put in your contract, it has nothing to do with your property. If the customer paid for this assets, then it's one thing. But you have to understand what rights you're talking about and what you want to protect and what you transfer. So if you have not mentioned this in your contract, then everything belongs to the author. You probably remember this scandal with Anna Chapman when she published her personal photos on your website, and then the newspaper Komsomolskaya Pravda printed those pictures using her website. So the question is what kind of agreement they had. A journalist was making those pictures for the magazine. So de jure, those rights belong to the magazine. But what about personal look? This is related to civil code. And it states very clearly what it is. It's very important to formulate clearly everything in the contract, and then you can choose one or other option. The cases can be different. Sometimes it depends on the source of funding. If we speak about state order, it's one thing. If there's a different situation, then the possibilities would be different. There might be some exclusive rights given to you. So everything should be clearly stated in the contract. Good afternoon. My name is Nikolai Zaychenko. I wanted to say two things. The first one is related to the website. It's part of software. No, it's it's related to copyright, but the website is content and design. And if you any use of software can be done only on the basis of agreement. So there's users agreement, and then you can say that any person that had access to your IP, it's very important to follow the regulations. Otherwise, the action will be taken to court. Then the other thing is related to law enforcement. We speak a lot about standardization or standards of proof. And if we continue this, we'll put on the same scale both arbitration courts and national courts. For example, the court says that some plenary decisions say that the court has to identify the amount of compensation. So it means that the court has to calculate all these things, but they never do it. But if we develop, if scientific community and practitioners and legal specialists are going to involve into this process, we'll be able to move ahead. The Western practices have been evolving over decades and centuries. We don't have such a practice, so we have to do it from scratch. So what should we do to prove that the right for patent has been violated? Should we calculate the cost of fake products or not, whether my license agreement is enough or not? And so these are all the questions that we have to solve to help our entrepreneurs work in the future. Hello, dear colleagues. My name is Dmitry Medlyaev. My question is related to the items to be registered by Rospatent. Rospatent's decisions are always challenged by the courts and appealed in the courts. So is there a system of responsibility for Rospatent for taking for making wrong decisions? Maybe the responsibility of employee or the manager or this organization. So how does it work? You probably don't know what Rospatent is as an organization if you ask such question, because the courts today have consider usually about 1,000 cases per year. And then to appeal or to challenge the decisions made by Rospatent. And I speak about different items, trademarks, industrial models, brands. So it's a very small percent, 1 point something. And I can assure you that most of those disputes are related to unfair or poor business. There is this concept of destroying patent, killing invention or killing trademark without any ground, and so.
So when a case is initiated against the registration of these patents, well, unfortunately, there are litigations that are conducted by our Department of Rospatent today. Sometimes the experts make mistakes, and there is quality control system. And let me assure you that if an expert violates the regulation established by Rospatent, it is personally liable and can be dismissed. The system works very accurately, and personal liability exists, beginning with the experts and up to the head who signed this decision. Today, about 100 experts have the right of signature because of their authority, professionalism. They have the right to sign in the name of Patent Management. Naturally, they are personally liable. And if this is identified, their right of signature is revoked. I won't agree with you when you are saying that if it is established that the expert violates the regulations. But do you know that patent disputes chamber reviews disputes based on the rules approved in 2005? Yes, we are to blame. It's another thing that today expert is not liable because, and neither is Rospatent liable. Maybe it's the problem of entrepreneurs that these issues, these disputes are not initiated. It's difficult for entrepreneurs to take this burden. However, we see that lack of responsibility of Rospatent leads to bankruptcy of entrepreneurs, and OPORA ROSSII needs to ascertain this. This is really so. We dismiss people who behave like that. Intellectual property rights issues are quite vague, and you can't say this is black and this is white. I'm expressing the position of an entrepreneur. You are part of Rospatent, so we need to do everything to improve the situation. Yes, your concern is clear, and I believe that when the new federal service is set up, we'll do everything possible to organize it and hear the voice of business in definite issues. Colleagues, there is no country in the world where patent department is responsible. They express government interests, and personal and individuals have personal liabilities. However, we are helpless here. We were to prepare 15 regulations. Beginning with 2008, we have only approved 2 regulations. However, this is not our fault. We have prepared all these regulations, and they're being approved in different instances. Entrepreneur from Tatarstan. I would like to discuss a different subject. How should I register intellectual property to avoid disputes? This is a very complicated issue. You really need to understand what you have. And based on this main issue, you should make a decision. Something can be registered, as Anne said, as an industrial design. Then you can see that there is an element of invention. And this is a result of certain scientific activities and is protectable. And you can discuss know-how that can be included in this patent and should be registered accordingly. This is a difficult issue, and the answer requires certain steps. Experts and consultants can answer this question and do it properly. This is true for everyone in this room. To protect something, you need to get a certain document. Why do we call it patent? Protection document. From the first patent of Queen Anne that was issued and the first patents in Italy for technical solutions, these have had the same meaning. If you think that you don't want to disclose the formula of your invention, and you may have problems of copying, especially when we discuss industrial design, then you should protect the know-how, commercial secret, and then you will get profit. A lot depends on the object. You need to understand, you have received a patent. However, this invention is used in certain complicated junctions, and then you can't see whether your invention is violated or not. You can't give a simple answer to that. You need to review this situation thoroughly on a case-by-case basis. I would like to ask about Singapore agreement. Is it used by Rospatent? Yes, we have ratified it. However, Rospatent does not take it into account. Of course, Russia is a party to Singapore agreement, and however, in patent chamber, they don't take it into account. If you have such facts, give them to me. I will deal with them. Please send it to my email. The last question. Ruslan, it is a practical question. I'm not a lawyer. The idea is this. We produce furniture, sofas, in fact. To copy this sofa, it is easy. We have some protection documents. However, the idea is as follows. Another producer does almost the same, but the quality is much lower. Naturally, we file a lawsuit about illegal use of our property rights, and the question is, how can we evaluate the volume of damage? Because by his quality, low quality, he undermines my reputation. Based on experience, yes, I must say that it is 18 months. The court litigation might ask last 18 months. In fact, these are specific questions, and maybe now we will stop our discussion, and if you have questions, you can ask a specific person and get an answer from them. Thank you very much, and see you again.